Number 6, the Streisand effect, which we spoke about a couple minutes ago, will prevent anyone from pursuing authors of defamatory content. A lot of people spread out around the world think that because of the power of the many, their ability to organize 1,000 people to attack a particular company in a coordinated way at any one point in time, that overwhelming threat will prevent anyone from getting sued for defamation. And we know that that's not true. It is something that needs to be very carefully evaluated and considered. But our each month, the Dozier Court Report, which we publish, which is a review of federal lawsuits, we don't focus on defamation. We focus on domain names, trademark infringement, copyright infringement, hacking cases. But every month we see trademark infringement cases that really are attacking defamers. Business-to-business litigation. Number 7 is the misconception is that the web is anonymous. What you have to be careful of when issuing a subpoena to go out and identify who is the publisher of information in the context of defamation. The threshold is a website that isn't the author of a post is immune from traditional publisher liability. Now that's a statement that you see bandied about time and time and time again. I will say this. The courts have recognized that that statute that was passed by Congress as part of the Communications Decency Act, giving immunity to these types of websites, is overly broad, has been interpreted in an overly broad manner. And the courts are restricting it. They're finding a ways around it. U.S. laws govern the Internet. We'd like to think that that might be the case. And for those businesses who are the subject of defamatory attacks, you're better off that it's not the case. When the web started really becoming commercially viable in 1997, all of the laws dealing with it were coming out of the United States. Then we started seeing laws coming out of the UK by 2000. EU started passing some pretty significant laws. Canada joined on. We don't know where we're going to end up or how we're going to deal with the Irans of the world and the Uzbekistans and Indonesias when they decide to start passing legislation that they feel should be applied to the web. But I suspect that they'll have much the same attitude that we have, which is our laws apply to everybody who does business on the web. The final suggestion I would make is to take this extra step to make sure that your client, if you're involved in defending someone's right to free speech, you make it clear to your client that it is inappropriate to undertake an attack against opposing counsel where this really in the essence isn't a free speech issue. It's an issue to gain advantage in litigation, and that's inappropriate. Now, a lot of the information we've discussed today is on our website, cybertriallawyer.com. It's www.cyber, C-Y-B-E-R, trial, T-R-I-A-L, lawyer, L-A-W-Y-E-R.com. You'll find the Dozier Federal Court Report link from that site that gives you by copyright, trademark lawsuits that have been filed and our summary of each over the previous 30 days. And also my blog. I've probably got 15 or 20 blog entries, rather extensive, on the issue of online defamation. It's been great spending 2 hours with you, and good luck in your endeavors.